Companies Act, Section 224, Actions to be taken in pursuance of Inspector's Report. Section 224 of the Companies Act, 2013 sets out the legal framework for the actions that may be taken by the central government after receiving a report from an inspector appointed under Chapter 14 of the Act. This provision ensures that appropriate remedial, punitive, and preventive measures are initiated based on the findings of a formal investigation into the affairs of a company or related entities. The section grants significant powers to the central government to take criminal, civil, or administrative action, including prosecution, winding up, filing of recovery proceedings, and seeking personal liability for wrongful gains, where warranted by the inspector's findings. 1. Prosecution for offences. When an inspector submits a report under Section 223, and it appears from the contents of that report that a person has committed an offence in relation to a company, or in relation to any other body, corporate or individual whose affairs have also been investigated under the same chapter, and such offence is of a criminal nature, the central government is empowered to initiate prosecution against that individual. The government is not merely permitted but expected to prosecute the person if a criminal offence is established. This provision underscores the importance of ensuring accountability and serves as a deterrent to corporate misconduct. It also imposes a duty upon all officers and employees of the investigated company or body corporate to provide the necessary assistance to the central government during the prosecution. This includes providing access to documents, testifying in court if needed, and not obstructing the process in any way. Thus, once guilt is found through a formal investigation, there is a clear path for criminal liability, and all internal resources of the company are expected to support the prosecution process. 2. Winding up of company or body corporate. This subsection empowers the central government to initiate proceedings for winding up a company or any other body corporate if the findings in the inspector's report justify such action. If the company is liable to be wound up either under the Companies Act or under the Insolvency and Bankruptcy Code, 2016, IBC, and the government finds that circumstances referred to in Section 213 exist, such as fraudulent conduct or mismanagement, it may take appropriate steps. Provided that the company is not already undergoing liquidation proceedings before the tribunal, the government may authorize any individual to present a case before the National Company Law Tribunal, NCLT, for a. Winding up the company on the grounds of it being just and equitable. b. Filing an application under Section 241 for relief in cases of oppression and mismanagement, or c. Filing both a winding up petition and an application under Section 241. This provision gives the government discretionary power to take corrective legal action where the continued existence of the company may harm its stakeholders or the public interest. 3. Civil proceedings in public interest. If it appears from the inspector's report that legal proceedings should be brought in the public interest for recovery of losses or wrongful property transfers, the central government can step in and act on behalf of the company or body corporate whose affairs were under investigation. The central government may initiate a. Proceedings for damages arising from fraud, misfeasance, or other misconduct associated with the promotion, formation, or management of the company or body corporate, or b. Proceedings for recovery of property belonging to the company or body corporate that has been misapplied, wrongfully retained, or unlawfully taken. The key condition here is public interest. This means that the government does not require the formal consent of the company to bring such actions. It may directly institute the proceedings in the name of the company itself. This ensures that justice is pursued even when the company's own leadership is complicit or unwilling to act. 4. Indemnification of the government. Where the central government brings proceedings in the name of the company or body corporate as described under subsection 3, it is entitled to recover the legal costs and expenses from that company or body corporate. This means that the company must indemnify, i.e., financially reimburse, the government for all reasonable costs incurred in such proceedings. The provision ensures that the financial burden of pursuing justice and recovery does not fall on public funds, especially when the affected entity stands to benefit from the legal remedy. This clause emphasizes the principle that companies should bear the costs of protecting their own interests, particularly where their mismanagement or misconduct has triggered legal action. 5. Disgorgement of undue benefit in cases of fraud. Subsection 5 is a powerful provision that focuses on disgorgement, a legal remedy used to strip wrongdoers of any unjust enrichment obtained through fraudulent means. If an inspector's report confirms that fraud has occurred, and it is established that any director, key managerial personnel, KMP, officer of the company, or any other person or entity has gained undue advantage or benefit, whether in the form of assets, property, cash, or other means, the central government may file an application before the tribunal. Through this application, the government can seek appropriate orders for disgorgement, i.e., a court-mandated return of the unlawfully obtained benefit, a declaration that the individual or entity involved is personally liable for the loss suffered by the company, and such liability is not subject to any limitation, i.e., it overrides protections such as limited liability status. This provision provides a powerful deterrent against corporate fraud by holding wrongdoers personally accountable and ensuring that fraudulently obtained wealth is returned to the company or its stakeholders. For more details, contact us.